Here in the matter of the State of Ohio versus Courtney R. Cudo, this is case 24-CR-252. Ms. Cudo is present in court. She is accompanied by her attorney, Mr. Matt Bangner. And we are here today, as it's my understanding that following an investigation by the Kirtland Police Department, the defendant is prepared to proceed by way of information, waiving her right to have this case presented to the grand jury and plead guilty to an information that the state has filed, charging one count of assault, felony of the 4th degree, and one count of operating a motor vehicle under alcohol or a drug of abuse, or a combination of them, misdemeanor of the 1st degree. It's my understanding with the tendering of a plea of guilty to the information, the state will be recommending a sanction of community control.
What's that line here, the last line you said?
Community control.
Oh, recommendation.
Recommendation, yes.
Mr. Bangert, does that sound accurate?
That is all accurate, Your Honor.
And Ms. Cudo, were you able to hear what the prosecutor just had to say regarding what she believes your plans are here today?
Yes.
And you can be seated during this. I don't interpret that as any disrespect. It's easier to be sitting down when we're going through this, so that's fine.
Thank you.
But you were able to hear what was said?
Yes, sir.
It was indicated to the court that you're going to be waiving your right to have this case presented to a grand jury, and I'll explain in more detail here in a second what that means. And then you're going to plead guilty to the 2 charges, which I will also review with you to make sure you understand those.
Yes, sir.
We will then continue the sentencing to a future day to get some evaluations completed, come back on a future day where there is no agreement. There is an agreement. There is an agreement between the parties at the time of sentencing that a recommendation for community control sanctions will be made. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do here at this time?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I am going to ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay, yes, sir.
All right. All right, well, let's get started then. How old are you?
26 years old.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
Do you have difficulty understanding? Okay. Were you able to understand the stuff that we've gone over? Okay.
Yes. Sorry.
So you can say yes, yeah.
Yes.
Did you graduate from high school?
Yes, sir.
Okay. Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
Just my medications that are prescription.
Okay. What are those that you've had just within the last 48 hours?
I take gabapentin.
Okay.
I take Visceral, which is hydroxyzine.
Okay.
I take Paxil.
Okay.
I have a Marina insert,
What's that?
the IUD insert. That's on
Okay.
my list. And then, as needed, I have Mupirocin and
Well, I'm just interested in what you've had in the last couple days.
Seroquel as well.
Okay.
Yeah, the as needed is Pepcid and Zofran, which I've taken.
Which one have you had within the last couple days?
The Pepcid.
Pepcid?
Pepcid.
Okay.
It's where is it? Famotidine.
You've had that within the last. That's the same. That's different.
Yeah, it's for. Well, no, it's the same name.
Okay.
It's for acid reflux.
Right. Okay. The reason I ask this is I want to make sure at this point as you sit here that you're not under the influence of any medications or illegal drugs, but it sounds like you haven't had any of that. But medications even that are causing you any difficulty in being able to understand what's going on. Okay. So these medications that you've had that you just told me, do any of them impact your ability to appreciate your surroundings, to communicate, to know where you are, what's going on? In a negative way. In a negative way.
Okay, I'm saying no.
Yeah, no.
I assume they help you if anything. Is that
Yeah,
fair?
yes.
Is there a mandatory fine for this DUI?
There is a mandatory fine, yes.
Which is what?
I believe 375 is the minimum.
Well, this is second
It's the
misdemeanor.
second, 675
Oh,
per
675.
second, I think it is.
Because you have 1075, that's the max.
That's the maximum.
But there is a mandatory minimum.
There is.
And what is it?
I understand it
We'll
to
pull
be
up the chart.
675, but I should.
But this is the second within 10
10.
years?
Wrong, it's 525.
Yeah, okay.
What is it?
525.
Before you came in here, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing and what you're going to be pleading guilty to?
Yes, sir.
You had a chance to look that over at some point?
Yes, sir.
Now, in that information, you are charged with 2 offenses. In count 1, what's alleged here and what you'll be admitting to is on or about January 27th, 2024 in Kirtland Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to Sergeant Eric LaTurner and or Officer John Sluga. Both of the victims were peace officers while in the performance of their official duties at the time, which makes the offense assault, a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, sir.
Any questions about it?
I don't think so. No, sir.
Okay. It took so long for this case to file. It's bound over in February.
I don't know the answer to that. I'm covering Ms. Naroda, but
There was just a lot of discussion with Ms. Naroda about how to resolve this case. A lot of medical things to talk about and go back and forth before we reach a resolution.
Bound over in February.
Well, I understand this.
On count 2, what's alleged here and what you'll be admitting to is on or about January 27th, 2024 in Kirtland Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. That conduct constitutes the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's a misdemeanor of the 1st degree. You understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about the charge?
No, sir.
Well, then before I can accept your guilty plea to these charges, I need to make sure you understand all the rights you're giving up by pleading guilty. Where's Ms. Naroda this morning?
I believe she was on vacation. She was
Oh,
going.
well,
to-
she's not in another
No,
court.
she was.
That's fine. I
Yeah.
mean, as long as I just want to see if she was in another court. All right. Well, first off, Ms. Kudo, you have the right to have this case presented to a grand jury. So that document I just read to you is called an information. What an information is, it's charges that are brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in the state of Ohio who's accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward on the charge brought by the prosecutor in the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can accept your waiver in your the waiver of the grand jury, I need to have you acknowledge that in open court in writing. So I have in front of me here a document called a waiver of indictment, which sets forth what I just explained to you about the grand jury process. And I want to give up that right. Before I can go any further, I need to be assured to understand this document that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over that with your lawyer. Is that correct?
Yes, sir.
Mr. Bangor, is that accurate? Did you review that and read that with Ms. Cudo? Is it Cudo? Am I saying that right?
Yeah.
And review that with her?
I did, Your Honor.
Did she indicate an understanding of that to you when you did that?
Yes, Your Honor.
Was that accurate, Ms. Cudo?
Yes, sir.
You understand what that document says?
Yes, sir.
And did you, in fact, it appears you signed it. Did you sign it here in court before I came out here?
I believe that was one of the.
It's
Yes. Yes, sir.
And Mr. Bangor, you witnessed that?
I did, Your Honor.
You as well, Ms. Milligan?
I did, yes.
All right, that'll be made part of the record. At this point, I'm going to go over with you all the other rights you have that you're giving up. If you have any questions, make sure you ask, but you first of all have a right to have a trial. And a trial could be to me as a judge, where I would listen to all the evidence and then I decide whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, guilty or not guilty, as each charge, whether you were guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you, free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence sticks with you and it stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case we're talking about, that burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of that charge, or both charges, beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, sir.
You all right?
Yeah, sorry.
You need a moment?
I'm okay, thank you.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and that's called cross-examination. So he could ask him anything he wanted to, within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir, I do.
Now, you'd also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness at your trial, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, I do.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
I don't believe so, no, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, I do.
Now, do you understand a guilty plea is a complete admission of guilt? So you're going to be admitting to the facts that are being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault, anything like that. Do you understand that?
Yes, sir, I do.
Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court, and then you'll subsequently, on a future date, be sentenced by the court. Do you understand that?
Yes, I do.
Now, in regards to count one, the assault charge is a felony of the fourth degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, count two, the OVI is a misdemeanor. Isn't there a minimum jail time for that too?
There is a minimum jail time of 10 days. Is that, I should have reviewed the form more diligently.
Now, in regards to count two, the OVI charge, it's a misdemeanor of the first degree. It carries with it a possible term in jail of up to 6 months, but a minimum sentence of at least 10 days has to be ordered. Do you understand that?
Yes, sir.
So a jail sentence of 10 days to 180 days would have to be imposed in that count. Do you understand that?
Yes, sir.
Now, while you're pleading guilty to two charges, if I were to impose a prison sentence on the assault charge, any jail sentence imposed on the OVI charge by law has to be served concurrent with a prison sentence. What concurrent means is at the same time, together. It doesn't. I can't serve them. I can't order that you serve them consecutive, meaning back to back. Meaning that you serve the sentence in one case, and when that's done, then you serve the sentence in the other case. I'm not allowed to do that. So any maximum prison sentence in this case then would be 18 months. I can't order, for example, you serve 18 months, and then when that's done, then you serve additional local jail time for the OVI. I'm not allowed to do that.
Yeah, that means they
Serving
don't
at the same
stack on top of each other to make it longer, so you get credit for one while you're doing the other one.
So if I did, again, this is hypothetical, but if you were sent to prison on the assault charge, any jail sentence, you'd be serving it at the same time while you're serving your prison sentence. It won't add to it.
Okay, I
Understand that?
understand.
So the maximum prison sentence you face in this case is 18 months. You understand that?
Yes, sir.
Now, are you currently on probation or supervision or any type of a parole or to any other courts or agencies?
You're not on probation anymore, right?
No, sir.
Do you have any other criminal charges pending against you in any other courts?
No, sir.
If a prison sentence were imposed at any point in this case upon your release from prison, you could be placed on what is called post-release control. It's sometimes referred to as parole. That's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it's not mandatory, but it could be up to 2 years. It's up to the parole authority to decide that. Do you understand that?
Yes, sir.
And if you ever are on post-release control and you violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, I do. My mouth gets dry from my medications. Sorry.
That's all right. Now, aside from the possible prison sentence, there are other penalties that can be imposed and some I'm required to impose. On the assault charge in count one, there's a possible fine of up to $5,000. Do you understand that?
Yes, I do.
You could also be ordered to pay restitution if that's applicable for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes, sir.
On the OVI, there is a mandatory fine that I'm required to impose of at least $525, and I could fine you up to $1,075. Do you understand that?
Yes, sir. I do.
This count also carries with it. What is it? License suspension.
I'm sorry.
One to 7 years is what I see.
I do understand 1 to 7 years. Privilege is possible after 45 days.
There's also a mandatory driver's license suspension I'm required to impose of at least 1 year, and I could suspend your license up to 7 years. Do you understand that?
Yes, sir.
You could also be ordered for both counts to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, sir.
A few moments ago, I explained the possible prison sentence you face. I used the word possible because prison's not mandatory with the count one assault charge. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation or granted probation? It means I'll consider that if that's what you're asking for. It appears you are. I'll look at all the information that gets presented. Then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be up to 5 years. And as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, sir.
So even if you get probation, doesn't automatically mean there's no jail time. There still could be local jail time in the Lake County Jail versus prison. You understand that?
Yes, sir, I do.
Further, if you're on probation, you're violating the conditions of your supervision, we will have a hearing to see if you're what's called a probation violator. If it's determined that you are, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, again, it could be 6 to 18 months in prison on count one. Do you understand that?
Yes, sir, I do.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf and recommend a sentence to the court. The prosecutor could also recommend a sentence to the court. Do you understand that?
Yes, sir, I do.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, It is just what I said. It's a recommendation, and I'm not required to follow that if I don't think that's the right thing to do. You understand that?
Yes, sir, I do.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
I don't believe so, no, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir, I do.
Have you had enough time to go over this case with your lawyer, have him review the reports with you, discuss the issues, and answer your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he or has anyone made any promises to you about what's actually going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, what you're pleading guilty to, the penalties you face, anything?
I don't think so, no, sir.
You need any more time to speak with your lawyer before we go forward with your plea?
No? Okay.
No, sir.
Okay. Then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we had a trial. I want you to listen to her and what she says, because I will have some questions for you. Understand that?
Okay,
Or
yes,
we
sir.
do that, I should say?
Yeah,
Okay.
yes, sir.
Ms. Mulligan?
Your Honor, the state would be prepared to show that on January 27th, 2024, in Kirtland, Lake County, Ohio, the defendant was driving a motor vehicle on Route 6 when a Kirtland officer observed her driving to be erratic, noting excessively low speed and frequent braking, drifting within the lane and ultimately crossing over the center line. He made a traffic stop and immediately observed an odor of burnt marijuana. The defendant admitted to smoking marijuana and showed him the remains of the marijuana that she had been smoking. She displayed characteristics of marijuana impairment, including lethargic speech and lethargic physical movement. She performed poorly on field sobriety tests. The two officers placed her under arrest for OVI, and during the course of that arrest, she attempted to bite one of the police officers and spit in the face of the other.
Were we able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial in this case?
Yes, sir, I did.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
That's where you say yes. If you did.
Yes, sir.
Very well. Regarding count one, charging with assault, a felony of the 4th degree, with the victims being peace officers and while performing their official duties, what is your plea to that count?
I plead guilty, sir.
Regarding count two, charging with operating a vehicle in the influence of alcohol, drug of abuse, or a combination of them, a misdemeanor of the 1st degree, what is your plea to that count?
I plead guilty, sir.
All right, I have in my possession at this time another document called a written plea of guilty and judgment entry, which sets forth everything I've just explained to you. Before I can accept your guilty plea, I need to make sure you understand this document, that you sign it here in open court. Now, my understanding, again, is before I came out here, you had a chance to go over this document as well with your lawyer. Is that correct?
Yes, sir.
Mr. Bangor, is that accurate? Did you review this and read this to your client?
I did, Your Honor.
Did she indicate an understanding of it to you?
Yes, Your Honor.
Is that correct, Ms. Cudo?
Yes, sir.
You understand what this document says?
Yes, sir, I do.
It also appears that you signed this document on the bottom of the 3rd page. Did you sign it?
I believe so, yes, sir.
Mr. Bangor, did you witness that signature?
I did, Your Honor.
Ms. Mulligan?
I did, yes.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count one, assault, a felony of the 4th degree, violation of 2903.13a, as well as count two, operating a vehicle in the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree in violation of 4511.19a1a. Of the first sentencing, order pre-sentence report and investigation, drug and alcohol evaluation, and a victim impact statement, or statements, I should say. Did you want a psychological evaluation at all, Mr. Bangerter?
That'd be fine, Your Honor. She has plenty of documentation on that she could provide.
Well, all right, we'll do a psychological evaluation also. I'll continue bond at the defendant's own recognizance. Do you have the bond condition form somewhere?
It's right here.
Continue bond at defendant's own recognizance with the condition of no driving a motor vehicle and no drugs or alcohol. So what all this means, this kudos as far as your bond goes, I'm continuing your bond, so there's nothing else you need to do, but you need to continue complying with the conditions of your bond. One of those conditions, again, is that you do not use any drugs or alcohol while you're on bond. You may be requested to submit to tests or provide urine screens. If you are, you have to do that. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Do you understand that?
Yes, sir.
Now, the purpose of these evaluations I have ordered is so I can learn more about you before sentencing. And the way the probation department gets that information they need to prepare the report is they're going to conduct some interviews with you. They'll administer some tests. It's important that when you meet with them and speak with them that you're open and honest with them, because they'll check and verify everything you tell them. If they learn you're misleading them in any way, they'll certainly let me know that, and obviously I would consider that at sentencing. You understand that?
Yes, sir.
Also, in order for me to be able to consider probation as an option at sentencing, those reports have to be completed, that pre-sentence report. In order for that report to be completed, the interview with you has to take place. So it's important that you show up on time, when scheduled, at the probation department for the purpose of that interview. Because if they cannot conduct the interview with you due to your lack of cooperation or showing up when you're supposed to, they can't prepare a report. And without a report, I'm not allowed to consider probation as an option. I won't continue the sentencing to a later day to get it done because it wasn't able to get completed on time because you didn't show up when you were supposed to. Do you understand that?
Yes, sir.
All right. All right, I think that covers everything. Ms. Mulligan, is there anything else for the record?
No, Your Honor. Thank you.
Mr. Bangerter?
No, Your Honor. Thank you.
Thank you.
the matter of the state of Ohio versus Aaron Wank. This is case 24 CR 512. Mr. Wank is present in court. He is accompanied by his attorney, Mr. Mulkey. And it's my understanding that he is prepared to withdraw an earlier entered plea of not guilty and enter plea of guilty to an indictment charging him with 2 counts, one of aggravated possession of drugs, a felony of the 5th degree, along with forfeiture specification for contraband, and count 2, tampering with evidence, a felony of the 3rd degree, again with a forfeiture specification for contraband. We would jointly ask the court for a pre-sentence investigation report and set the matter over for sentencing. There is no agreement as to recommendation.
Thank you. Mr. Mulkey, does that sound correct?
It does, Your Honor. I went over all this paperwork with my client, had conversation with him as recent as last weekend this morning regarding all of this. Thank you, Your Honor. We're prepared to go forward.
Thank you. Mr. Wank, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty and enter a plea of guilty to the 2 charges which were just outlined, and I'll go over those with you here in a second to make sure you understand them. We would then defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, more importantly, what you want to do here today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I will ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Thank you, Your Honor.
All right, good. Well, let's get started then. How old are you, sir?
I'm fantastic this morning. Got a chance to get off of work and be here today with you guys.
I said, that's good. I'm happy about that. But
Fantastic.
my question was, how old are you?
Oh, how old am I? Apologize. 28 years old, Your
All
Honor.
right. We're all right. I'm glad you're doing well.
Thank you, Your Honor.
All right, let me backtrack. You threw me off my thing here. You able to read and write the English language?
Yes, Your Honor.
Any difficulty with that or difficulty understanding what you read in English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, Your Honor.
Now, you should have been served with a copy of the indictment in this case. Looks like you probably got it end of July, very beginning of August. That's the document that sets forth what the charges are in this case. You remember getting that document?
Yes, Your Honor.
And at some point, did you have the chance to look that over?
Yes, Your Honor.
Now, in that indictment, you are charged with 2 counts, and you're going to be pleading guilty to both of these counts. And count 1, what's alleged here and what you'll be admitting to is on or about January 27th, 2024 in Eastlake Lake County, Ohio, that you did knowingly obtain, use, or possess methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. The amount involved in this case was less than the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, the charge also carries with it what we call forfeiture specification, which alleges that during the commission of the offense, you possessed or had an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, whereas an instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner or to help facilitate the commission of a crime. You can't possess it and use it for that purpose. And here it's alleged the methamphetamine itself with all the packaging is contraband and instrumentalities. And the whole point of this is that you forfeit any ownership right you have to that property. Do you understand that?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, in count 2, what's alleged and what you'll be admitting to is on or about January 27th, 2024 in Eastlake Lake County, Ohio, that you, knowing an official proceeding or investigation was in progress or is about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the third degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, Your Honor.
Any questions about that for me?
No, Your Honor.
Now, that charge also carries with it that same forfeiture specification. You understand that?
Yes, Your Honor.
Well, then, before I can accept your plea of guilty to these 2 charges, I need to make sure you understand all the rights you are giving up by pleading guilty. And you, first of all, have a right to have a trial in this case. Now, that trial could be to me as a judge, or I listen to the evidence, and then I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, and that will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. What that actually means, it means that all 12 jurors would have to agree together, one way or the other, as to each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, Your Honor.
And if we had a trial, the prosecutor here will be representing the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of both of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden there is in our justice system. And what it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges itself beyond any reasonable doubt before you can ever be found guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would be calling witnesses to come to court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to, but within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do this, and you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order, and we call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to. But you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty of either of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding that I will enter if I accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
You understand them all?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty in count 1 to a felony of the 5th degree. It's the drug charge. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, count 2 is a felony of the 3rd degree. This offense carries with it a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, 30. So if I determine a prison sentence was warranted for this count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve on that count. Do you understand that?
Yes, Your Honor.
Now, since there are 2 separate charges here, 2 separate offenses, if I imposed a prison sentence, I would impose a prison term on each separate count. And as the judge, then I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means you serve them together, and you'd serve them at the same time. Whereas consecutive means one after the other. You'd serve the prison term on the first count, finish that, then serve the prison term on the second count. You understand the difference there?
Yes, Your Honor.
So in this case, if I imposed a maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison sentence of 48 months or 4 years in prison. You understand that?
Yes, Your Honor.
Are you currently on probation or parole or any type of supervision in any other courts or agencies?
No, Your Honor.
Do you have any other criminal charges pending against you in any other court?
No, Your Honor.
If a prison sentence was imposed in this case upon your release from prison, you could be put on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served whatever the prison sentence was. And in this case, it's not mandatory, but it could be up to 2 years, up to the parole authority to decide that. You understand that?
Yes, Your Honor.
And if you were put on post-release control and you were violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined in this case. On count 1, you could be fined up to $2,500. On count 2, you could be fined up to $10,000, so a maximum fine altogether of $12,500. You can be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
The drug charge in count 1 also carries with it a possible driver's license suspension of up to 5 years. Do you understand that?
Yes, Your Honor.
And as I mentioned earlier, regarding those forfeiture specifications, any right, title, or interest you have in any of that property will be forfeited to the state of Ohio at the time of sentencing. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison is not mandatory or required in this case. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're going to be asking for. I'll look at all the information that gets presented, then I'll make the decision that I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be up to 5 years of supervision, and as the judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in our Lake County Jail of up to 6 months as a condition of your probation. Do you understand that?
Yes, Your Honor.
Further, if you're ever on probation or community control sanctions and you're violating those conditions of your or rules of probation, we would have a hearing here in court to see if you're what we call a probation violator. If it was determined that you were, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, again, it could be 6 to 12 months on count 1, 9, 12, 18, 24, 30, or 36 months on count 2, consecutive for up to 48 months. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you will have the right on that day to say anything you want. Anything you want me to know or you'd like me to consider, your lawyer could speak on your behalf. He's allowed to recommend a sentence to the court. The prosecutor could also recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Now, do you understand that whatever anyone says at sentencing, including the lawyers in regards to what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty to these charges here today?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk with your lawyer about this case and have him go over everything with you and answer your questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel?
Yes, Your Honor.
Has he, or has anyone for that matter, ever or made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty at this time?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your plea freely and voluntarily?
Freely.
Do you have any questions for me at this time regarding anything we've just talked about? Your rights, what you're pleading guilty to, the penalties you face? Any questions?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with your actual plea of guilty?
No, Your Honor.
Now, what we're going to do at this point, the prosecutor here is going to explain for me what what she believes the evidence would show if we had a trial. I need you to listen to her and what she says, because I will have some follow-up questions for you, all right?
Yes, Your Honor.
All right, Ms. Mulligan?
Your Honor, the state would be prepared to show that on January 27, 2024, in East Lake, Lake County, Ohio, the police were called to the Fifth Third Bank with a report that there was someone in there behaving in a strange manner. When officers arrived, they located the defendant outside of the bank on the street. They went up to talk to him to see what was happening, and as they approached, the defendant took a plastic baggie out of his trouser. It appeared to have a white powder in it. He ripped that baggie open with his teeth and consumed the white powder. The defendant was taken to the hospital. The plastic bag was taken to the Ohio State Highway Patrol laboratory and determined to contain residue of methamphetamine, a Schedule II substance.
Mr. Wank, were you able to hear what the prosecutor had to say regarding what she believes the evidence would establish at a trial if we had a trial?
Yes, Your Honor.
What, if anything, did you have to say about those facts as she presented them? Are they true? Did you do as she said?
Yes, Your Honor.
Very well, then, regarding count 1, charging with aggravated possession of drugs, a felony of the 5th degree, what is your plea to that count?
Guilty, Your Honor.
Regarding count 2, charging with tampering with evidence, a felony of the 3rd degree with the forfeiture specification, what is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and what it says and sign it here in court. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Mulkey, is that accurate? Did you review this with Mr. Wank and go over it with him?
I did.
And did he indicate an understanding of that document to you?
He did.
Is that correct, sir?
Yes, Your
You
Honor.
understand what the document says?
Yes, Your Honor.
Do you have any questions for me about what it says?
No, Your Honor.
It also appears that you signed the document. Did you in fact sign it?
Yes, Your Honor.
Mr. Mulkey, you witnessed that?
I did.
Ms. Mulligan, you as well?
I did.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea and find the defendant guilty of count 1, aggravated possession of drugs, a felony of the 5th degree, with a forfeiture specification in violation of 292511 of the revised code, as well as count 2, tampering with evidence, a felony of the 3rd degree in violation of 2921.12A1, felony of the 3rd degree with the forfeiture specification. Now, the first sentencing, order of pre-sentence report investigation, drug and alcohol evaluation. I will continue bond. I have 5,000 cash surety, 10%. That will be continued. So what all this means, Mr. Wank, as far as bond goes, your bond's being continued from what it was. There's nothing more you need to do. You do need to, however, continue complying with the conditions of your bond. One of those conditions being no drug use while you're on bond. You'll have to submit urine screens if requested. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Do you understand that?
Yes, Your Honor.
Now, the whole point of this pre-sentence report is so I can learn more about you. And the way the probation department gets the information they need to prepare the report is they're going to conduct some interviews with you and administer some tests. It's important that when you meet with them that you're open and honest with them because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they'll let me know that. I certainly would consider that at sentencing. You understand that?
Yes, Your Honor.
Also, in order for me to be able to consider probation as an option, this report has to be completed. And in order for that report to be completed, that interview with you that I mentioned must take place. So it's important you show up on time, when scheduled at the probation department for the purpose of that interview. Because if they can't conduct the interview with you, then they can't complete a report. And without a report, I'm not allowed to consider probation as an option. And I won't continue it to a future day to get it done because it wasn't completed on time due to your not cooperating with them or showing up when you were supposed to. Do you understand that?
Yes, Your Honor.
Right. So you're going to leave here now. You're going to go over to the probation department, fill out some initial paperwork, and get your dates to come back. So make sure you go over there when you leave here at this point, all right?
Thank you, Your Honor.
All right. Ms. Mulligan, anything else for the record?
No, Your Honor.
Mr. Mulkey.
Not at all, Judge.
Thank you.
All rise. Honor, we're here this afternoon in case captioned State of Ohio versus Khadijah Berry, case number 24 CR 000051. We were last here on August 8th, at which time the defendant entered a written and oral plea of guilty to one count of assault, that being a felony of the 4th degree in violation of revised code section 2903.13A, this involving a police officer. The case is referred for a pre-sentence report and investigation, victim impact statement, and a drug and alcohol evaluation. We are set today for sentencing, and we are here today for purposes of sentencing, and the defendant is present with her counsel, Ms. Rachel Smith.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you would like to say on behalf of your client?
Yes, Your Honor. On behalf of Ms. Berry is 27 years old. She's a single mother to a 12-year-old son. She has learned since she was arrested that she is also pregnant and expecting her second child. Ms. Berry is a high school graduate. She graduated from Euclid High School in 2005. She was an honors student, has completed some college. She works at Benchmark Home Services with intellectually disabled individuals, and is also enrolled at Journey Barber School, which she's scheduled to complete in November of 2026. Ms. Berry did not set out to be a single mother. She became a single mother 7 years ago when her son's father died in his sleep in bed with her. Ms. Berry has indicated that from rising from that and since that time in her life, she developed some unhealthy coping mechanisms that involved the use of alcohol, and that alcohol was a significant contributing factor to the offense in this case. Your Honor, adding credence to Ms. Berry's proffer of that is that Ms. Berry, when she addresses the court today, in her interactions with myself, I believe in her interactions with probation, presents as a very different person today than she did on the day of the instant offense. On the day of the instant offense, Ms. Berry was difficult, to say the least. She was aggressive. She conducted herself in a way that is not proper and in a way that she has accepted responsibility for, and I believe will indicate her remorse to this court for as well. Ms. Berry has a minimal criminal history. However, due to her alcohol use, it has been increasing in the recent years with a misdemeanor offense in 2020, 2021, and now the present offense. Ms. Berry has spent 55 days in the county jail. She is committed to her sobriety as well as addressing the trauma history that she believes has led her to drink. And to her credit, Ms. Berry has not had a drink of alcohol since she was released initially from the jail in January of this year and is engaged with Alcoholics Anonymous. She is asking the court to place her on a period of community control. Will follow any conditions that the court sets out for her and looks forward to any treatment that the probation may feel is appropriate.
Ms. Berry, you have the right to address this court before you're sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes, Your Honor. I would first like to apologize to Officer Schultz for my actions the day of the incident. I truly apologize. I'm a changed person. I just want to do better. I just want to be a mom to my kids. And I want to apologize to my mom for adding this extra stress on her. She has enough going on right now. So I'm just ready to go home.
Thank you. Ms. Smith, anything else on behalf of the defense?
Not at this time, Your Honor.
Bless you. Bless
Thank
you.
you. Thank you. All right. Ms. Linden from State.
Thank you, Your Honor. Your Honor, as was set forth at the change of plea in this matter, we are entering into a joint sentencing recommendation for community control sanctions. I would point out in this case involving the officer that she did bite the officer, but it was over top of his shirt, and so it did not end up breaking the skin or causing a mark. But looking at her history with the assault charges, that she's had before. Obviously, things have escalated for some reason or another. We would ask that she be in anger management, definitely that some sort of drug and alcohol issues be addressed through treatment, whatever whatever the court deems appropriate in terms of that treatment. She does have 55 days of credit for time served.
Are you aware, do you know, or Jennifer, that this second, I'm assuming the first assault, like in 20, that was amended from an F4 would involve police because it was an F4. What about the second one, the misdemeanor assault? Can't tell from the bleeds probably. I guess I can. Give me one second.
Sorry, Your Honor.
I got it. No, it did not.
I don't see it in.
I got the docket in front of me from that case. I just pulled it up. It was a Willoughby case. It was a simple assault. We reviewed the pre-sentence report and investigation, the drug and alcohol evaluation that was completed. I've considered the facts and circumstances of the offense involved, the nature of that offense. I've considered what's been said here today. And Ms. Berry herself, her attorney, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. Factors in 292912. Nothing stands out factually to this court indicating it's any more or less serious than what normally constitutes assault on a peace officer. As for recidivism factors, the court does note the defendant has a history of criminal convictions. This is not our first conviction. It's not our first assault. It's not our first assault involving a police officer. It's your third conviction for assault. Second one involving a police officer. All within a few years. She violated the conditions of her bond in using marijuana while she was on bond. It's a factor indicating recidivism more likely. Alcohol problem that obviously related to the offense, at least that's what the defendant says, that alcohol was an alcohol problem. I guess it was something that she was under the influence of. She indicated it was alcohol. I don't have any reason to question that. Certainly don't believe or find that she denies any history. She's admitted it. Hasn't gotten treatment for it, though she's taken her own steps in regards to going to AA meetings, I believe. Again, this is what she has reported. I have no reason to say she hasn't done that, but there's no treatment program. As for factors indicating recidivism is less likely, the court notes there's no prior juvenile delinquency adjudications. Appears the defendant has genuine remorse. Under 2913B1, court finds defendant caused physical harm to a person, also attempted to cause physical harm to a person as a prior conviction for causing physical harm. Despite that finding, the court finds at this time that prison would not be consistent with the purposes and principles of sentencing. The defendant's amenable to available community control sanctions. The problem I have, however, is, again, this is the third assault conviction that you have in the last few years. Second one involving a police officer. That can't just be ignored. Normally, I mean, we get assaults on police officers. Many people charged with that are going to prison. This is your second time you've done that. Certainly has to be consequences for that. Also, if you're claiming you were as drunk as you were and you don't remember any of it, it was the next morning, right?
Yes, I did.
And you were driving a car, and you can't remember anything, and you were in that condition that the next morning after you were drinking, you don't remember anything that happened, and you're about to be driving a car? I don't know how credible that is, to be honest with you. As I said, I'm going to give you a chance with community control sanctions. I'm going to place you on community control sanctions for a period of 2 years. But one, there's got to be consequences. And two, the time that you've spent in jail so far is on you. You were out on bond. You failed to appear for your hearing, but you turned yourself in the next day or 2 days after. I can't remember exactly. And I was inclined to reinstate your bond, but you tested positive for marijuana. And that's why you've been in jail this whole time, because you didn't follow the conditions of your bond. I'm not going to alter or change what I would normally do and what I think should be done, especially in regards to treatment, because you've spent 50 days or 55 days in jail, but when that jail time is on you. And it's not what, I didn't impose that. You, in a sense, gave yourself that time by not complying with the conditions of bond. So I'm going to order, again, 2 years community control sanctions. I'm going to order the defendant serve 100 days in jail. She has credit for 55 she's served. I'm going to order that she immediately get into the jail treatment program, which the minimum time you need for that's 45 days, and that's all I'm sentencing you to. Enter that program, successfully complete that program, follow all their aftercare recommendations. Further conditions, then, you're not to use any drugs or alcohol. That includes no marijuana, no gummies, no CBD supplements or whatever that stuff is in the stores that you can find. Nothing with THC or any drugs.
I'm not, Your Honor. I'm pregnant, and
I can't hear you.
I said I'm not. I'm pregnant, and I just want to get prepared for the arrival of my baby.
It's good, and the fact that you're pregnant, I would hope you wouldn't do that, but believe me, you're not the first person that's pregnant in here, and most of them that are in here that are pregnant are using drugs still. And I'm not saying you're gonna. I seem to be sincere about that, but it's not unusual for us to see, I can tell you that. You're to obtain and maintain full-time employment or education or some combination of the two, but keep yourself busy. Full-time basis. I want you to get a mental health evaluation and follow whatever recommendations are for counseling, so you can deal with the what's causing you these issues. The incident occurred there with your ex. It was in 2017, I think it was.
Yes.
You need to deal with that the right way. Get some help with that. You can also attending your management counseling while you're doing that. I said, but 3A meetings a week with the sponsor. I may have forgotten that. Take all medications as prescribed. Pay court costs and supervision fees. Jennifer, anything else I should be thinking about here?
No, thank you, Your Honor.
So, Ms. Berry, you understand the conditions of your probation?
Yes.
I'm sure you're not thrilled with having to do another 45 days in jail. I get it, but I believe you need the treatment program. I believe you need to be punished. You get through these 45 days, your conditions of probation basically are don't use any drugs, stay out of trouble, get some counseling, which can only help you,
Okay.
and work.
Okay, can you put an order in for the jail to take me to the doctor? They still have not taken me to the doctor. I don't know anything about my pregnancy other than I'm pregnant.
How'd you find out you were pregnant? You were suspected, so they gave you a test or something along those lines, or?
Around my 9th day there, my cycle was late,
Oh, okay.
and I took a pregnancy test, and I still have not.
I can't put an order. I don't order them what to do, but I'll make a phone call over there and see what's going on.
Okay.
I don't order the sheriff's department in regards to how they conduct their business and medical stuff, but I'll make a phone call.
Thank you.
How
I don't
far
know.
along do you believe you are?
Possibly 3 months, probably 4. I don't know.
Do you understand the conditions of your probation? Do you have any
do.
other questions for me?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your probation will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you. I could terminate your probation and send you to prison. If I did that, it would be 18 months in prison. That'd be consecutive to any other sentences that you may be serving at that point for some other case or that you may get sentenced to. All right, is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Ms. Smith?
Not on behalf of Ms. Berry.
All right, thank you.
Thank you, Your Honor. If it please the court, we're before the court this afternoon in the matter of the State of Ohio versus Nicholas Giordano, case number 24-CR-745. The defendant is present in the courtroom, his attorney, Mr. Antonio Nicholson. We're before the court this afternoon for purposes of sentencing the defendant having pleaded guilty to count 3, felony of the 4th degree, receiving stolen property, motor vehicle. Parties are ready to go forward, Your Honor.
Thank you. Mr. Nicholson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Your Honor, Mr. Giordano is 23 years of age. I'm happy to say he is a high school graduate. I believe he graduated from Harvey High School. Your Honor, look, it's an understatement that his record is atrocious. I mean, he's got several convictions as a juvenile. I get it. But he is young. Look, I've spoken to Mr. Giordano, and I've had some very, very frank and firm discussions with him. I talk to my clients a little bit differently than other attorneys do because some clients, my younger ones, are tough to get through to. And I know how to respond to them. And they, quite frankly, respond. Not all of them respond positively, but my young clients, for the most part, respond to me because I talk to them in a certain way that probation officers, prosecutors, even their own parents don't speak to them in, because you have to. He's very comfortable opening up to me. And he's indicated to me that he's sick of being in the system. He's sick of being in the system. He's got 3 kids now, 2 on the way, I believe. He's 23 years old, and he is sick of being in the system. And I keep telling him, and he don't want to hear this. And I almost use another word, but he irritates me sometimes when I talk to him because I understand where the probation officer is coming from when she says that he comes off with this cocky attitude, with this, I don't need nothing, this and that. And it irritates me when I talk to him sometimes. Quite frankly, I was irritated when I came out and talked to him. And he gave me that same attitude. But then, as I know how to get through to this young man, I sat him down, I put my arm around his shoulder, and I said, and he won't repeat this because between us, but I said some very frank things to him. Some very true, some very real things to him. I had a very come to Jesus moment with him. So I'll leave that at that. And he responds. Like I said, he's been to prison. Pay attention. He's been to prison before. I get it, but Your Honor, he was younger then. He didn't have all of the responsibilities that he had when he went to prison. And he's been given chances. But you know what, Judge? Like I said, sometimes it takes people a little bit longer than others to respond to authority and things of that nature. I think he has a very, very, very promising future. I mean, he's got stuff on his record, but I'm not seeing anything like crazy. I mean, this is just, don't minimize his record at all, because he's been on trash in the past few years. But there's nothing that is incapable of redemption. Nothing. Like I said in chambers, I was just put on notice that while he was out, his mom indicated to me that he assisted. He's got a sister with Down syndrome who, to my understanding, has feeding tube. He has assisted his mom when he's not on trash. He's assisted his mom, lengthy assistance in helping her care for this child, helping assist put the feeding tube in this child, helping be the caregiver. That was the information that was given to me. Now with him in here, and for his own fault, now it's strained because his mom has to take care of the younger sister. The father has to take care of the younger sister. So my understanding, there's a successful family restaurant that has to be left to do so. The family is losing money. I just found out about that. I don't know why I didn't mention that to the probation department. But like I said, Judge, when you're speaking to probation officers, and he's got a history of it, but you're speaking to strangers. You're speaking to people that you don't know. You're speaking to people that want to get into your business, and you don't trust them. Because at the end of the day, while we know, when you're in this profession, you know that the probation officers are here to help, and they're here to make sure that he don't keep reoffending, or if he does, put him in jail. But we know that the probation officers here are here to help. They don't know that all the time. I mean, you got somebody 23 years old, think he know everything. I'm not saying it's okay that he doesn't open up and respond properly to the probation department, but I get it. It's hard to tell somebody you got a drug addiction. It's hard to tell somebody personal things about you and open up. And it's easy to just show up. I'm not using that as an excuse, but I think I've had more time to talk with Mr. Giordano and really relate to him and really find out and dig into what it is that is causing this behavior. I've had more conversations than anybody in this courtroom with him. Personal conversations, because I know this honorable court has seen him and had some conversations with him. But I really genuinely believe that him having to listen to his daughter, because his daughter doesn't know what's going on. His daughter doesn't know that he's in jail, and having to listen to that and listen to his daughter say, look, where is daddy? Daddy, when you coming home? When is this? When is that? I mean, that's taxing on an individual. That's taxing on an individual. You can see, now, a lot of people might say, oh, he crying in front of the court just because he don't want to go to prison. No, I think he genuinely misses his daughter. He's been away from his daughter for some time. And I think his eyes are open because it ain't just him. It's not just him screwing up his life. He's got other human beings that depend on him. Not to mention a loving mother of whom I spoke to several times when this case commenced, who I was in constant contact with. I mean, his mom wanted to get him out on bond, but couldn't do it and got the resources to deal with his trash and then have to support the other family structure. I get it. Everything is screaming, he's not amenable, he's got a record, blase, blase, blase. Well, I'm here to say, look, he's still young. I was 23 years old, and I ain't have a record. I ain't have a rap sheet a mile long like this, but I get it. And like I always say, we focus on the what so much. Why does he have a criminal history? Why does he have cases ranging all the way back to juvenile as a juvenile? And I think we should focus on that because, like I said, I mean, he gonna get out. You can max him out today. He's going to get out. But we see a history. We see a history of criminal behavior. He can do 18 months like it's nothing, probably. I get it. It's going to hurt. It's going to sting because that's another 18 months that he can't be with his daughters, be around his family. He can do 18 months. But what's going to happen? He's going to come back out here, and we're going to hope, we're going to pray that he got it together in jail. Young men, you know, I just don't have the confidence. I don't think they had, me personally, I don't think they had the resources in prison to help him with redemption. I don't. But I do think we have resources in the community. And there are alternatives to prison. There are. And we can use them. And I know he's been to prison before, but Judge, I'm asking you to see through it, to just put this aside for 1 second. And you have given him probation before. But I think he's got more to lose now. I think he's got a little bit more to lose now than when he was 18, 19 years old. And I'm asking you, Judge, whatever we have to do to craft out an appropriate sentence, look, maybe he might have to sit in for 6 more months. I don't know. But we do have a thing called local incarceration. And he's looking at 18 months. I get it. But maybe he might have to sit it down locally until he gets the problem, gets the point. I'm asking the court to give him a shot. He's been in the entire time. I'm asking the court to give him one more shot. And if he wants to be stupid enough, I take that back. If he wants to be unintelligent, and if he wants to put other things above the most important priorities, above his family, above the sister that I've been told that he assists in taking care of, above his children, then you know what, Judge? Give him his full 18. But, Your Honor, I'm asking, I think he's a different person mentally than he was when he went to prison some time ago. Got a lot more to lose right now, and I don't want to give up on him. So I'm asking the court to fashion out a sentence. Maybe he might have to be shot. I don't know. But I'm asking the court to fashion out some other sentence other than prison. Maybe some local incarceration and a stern talking to and a short leash. Because like I said, I'm not going to bite my tongue. And I'm not saying this court just throws people in jail. I'm not saying that. All I'm saying is, as a criminal defense attorney for the past 10 years, trying serious cases, handling serious cases, being in the community, it just gets, it hits me when I continue to see, well, any people, but particularly in my community, young African Americans go into the prison system and just keep the revolving door going, and having children who, quite frankly, they're just warming up the seat for. Now, I can't say that his kids are going to join him in a life of crime. I don't see that happening. I hope it doesn't happen. But I can tell you this, it's going to happen sooner than later if he continues to engage in this life that he's engaged in. I get it. I get it. People are sick of him. But like I said, I think he has a little bit more to lose right now. He's got a little bit more on the line right now. And I know we're talking about 18 months, but that's 18 months. I don't want to spend 18 seconds in jail. And I've lived my life to the point where I don't have to. But Judge, I'm asking you, give this young man a chance, one more chance, because you have given him a chance. I don't want to deminimize that. You have been fair to him. I'm asking you, Judge, to go one more step further for him. I'm asking you. I know you bent over backwards for Mr. Giordano. I'm asking you to bend a little bit more, just a little bit more. And I know he doesn't deserve that, but I think he does. I would ask you to give him the opportunity to show you that he can change, and that this ain't him. All these crimes and stuff, violation. Give him a chance to show you. And keep him on a short leash. And the minute that he messes up, boom, send him. But it's my job to advocate for him. He is a young man. He does have redemption. His criminal record, while it is lengthy, I haven't seen anything that says, man, this dude belongs off the street. I haven't. So, Your Honor, I think his mom would like to address the court. I'm pretty sure he would like to address the court. I would ask the court whatever sequence that the court deems it appropriate. I'd ask the court to allow them as such, and everything I've said, I'd ask the court to take in position into. Oh wait, I had one more other thing to say. And I understand. If your daughters or your kids are so important, why are you out being stupid and not doing jobs, having a job? Why aren't you employed? I get that. And that's the question I have for him. Because he's not a bad-looking dude. I mean, he got tattoos everywhere, so, I mean, he's just going to have to be able to cover those when the time comes. But he can clean up well, get a haircut, put a suit on. He can get a job. There's nothing on this list that's keeping him from getting a job. Heck, his father owns a restaurant. He can get a job. I will tell you this, though. Priorities are not as important when you're 18, 19 years old as opposed to when you're 23 with 3 kids or 1 kid and 2 on the way. So to ask the court, when we think about why doesn't he have a job, why is he doing this, if he so cares about his kids, head wasn't in the right place. But I guarantee you, in excess of 106 days straight, he's had some time to think about it. Didn't have a daughter on the phone telling him, come home, come home, come home, come home. At least I don't know if he did or not. I'm not privy to his conversations when he was in prison. But now he's faced with that, and now he's got a lot to lose. I've ranted enough, Your Honor, but that's what I do. I'm going to ask the court to give him a shot. And if the court does give him community control, I'm with the probation officer. You either going to do it or you're going to do it. And if you're not, don't waste it. Do not waste do not waste our resources. Do not waste our time. If you're going to do it, do it. If you're not, do your time and keep it moving. And I'll leave you with that, Judge. Thank you.
You can hear from the defendant's mother at this time. Ma'am, if you want to address the court, you can stand right where it is that you're seated, state your full name, and you can say whatever to me you want me to consider.
I was hoping that he could just get probation, and then when he gets out, he was in with Crossroads. I was gonna try to help him get back into Crossroads into counseling and help him get a job so that he could come home. Because I think right now he needs his family and his daughter. And I was just hoping, like I said, he could just get probation.
Can you explain to the court how he assisted you with your daughter, I believe, with Down syndrome? Can you please be specific about that?
He would, my daughter, she has Down syndrome, she has a feeding tube, and she has a pacemaker. He's really good.
How old is she?
She's just turned 18, but her mind is as a 2-year-old.
This is his sister?
Yes, his sister. Yes. He would get her off the bus, and he would hook up. It's like like when you have like the IV, we have the pull at home. He would put the insurance in the water. And
What's her name?
Destiny. And he would take care of her until I got home. And he's really good with her. She's like really good with like Nick. Like he's basically the one that got her to talk more and help her read. Outside of like how he got himself in trouble, I know he's really good at home. Like he helps me out a lot. He helps me. He was working at Popeye's manager. He was helping us at home with bills. I just know that he just made a mistake, and I was just really hoping that he could just be put on probation and just be with his family and just go to counseling and just try to figure out, if he could just get his mind right. I feel like that's what Nick needs, just to be with his family and not in prison. I really just don't want to see my son go to prison. I just feel that he needs help, not to go to prison. He needs help in his family right now.
Thank you. Mr. Giordano, you have the right to address the court before you're sentenced. Anything you want to say at this time?
Culotta, I know I've been in front of you before. Back then I was a lot younger. I didn't take nothing serious. Went to prison, thought everything was a game. When I came home, my daughter was a little bit older, so I spent a lot of time with my daughter. It was just me and my daughter for like a year. My child's mother, she was going to truck driving school. Still doing good. I got a job. I was working at Popeyes. Everything was going good.
Why didn't you report your job? In your PSR, no employment history was given by you.
I had.
No, I want
Your
to
Honor,
know.
I apologize.
Did not give an employment history in the pre-sentence questionnaire.
Yes, Your Honor. I had came in here. I had got fired, so I didn't want to say it. I mean, Your Honor, I honestly wasn't thinking, Your Honor. I just came in there. I wasn't using my head, Your Honor. But now, I really want to change, Your Honor. It's not about me. It's about my daughter. Every day I'm on the phone with my daughter. Daddy, where are you? My mom gets her every weekend. She's going in my room. Where's Daddy? Where's Daddy? When I was out there, wasn't really thinking about that. But now I've been incarcerated for this long. I'm not the one suffering. My daughter's the only one suffering. My family's the only one suffering. Yeah, I'm doing time. I mean, I'm thinking about everything. I'm in my cell at night. I'm thinking about my daughter. I really want to get out and change. I want to get into ATEC, get my welding certification.
I can tell you all of this, but I have to want it, Your Honor. I have to get out and really do the right thing. I got another kid on the way. I have a son.
2 on the way.
Yeah, I have a son on the way, and a daughter on the way. My son is due next month. I don't want to be locked up. I want to be out there to see my son born. I want to be out there. So I'm just asking. I know you gave me a shot before. I was a lot younger, and I wasn't. This time, I really want to take things serious so I can get out, help my mother, and just do the right thing, Your Honor, and prove to courts that I can actually be a living by a citizen and do what I have to do, Your Honor.
Why didn't you ever mention anything on this questionnaire about having a sister? You said you have a sister who's 29 years old.
I told Kim that I have a sister that has Down syndrome. I told her that.
Kim?
Your Honor, I don't remember that.
4 years ago when you did your pre-sentence report, you mentioned nothing about a sister. I have the pre-sentence report from 4 years ago that you did. There's a section for siblings. You listed your older sister.
Yeah.
Never mentioned anything about anyone else. This time, same thing.
Yes, Your Honor.
And I'm hearing today for the first time that you have a younger sister. You have the questionnaire probably, right, Kim? That he fills out?
Yes.
That lists siblings?
It has the first sister's name on it.
Your Honor.
He said we talked about it, but I don't remember that, Your Honor.
Oh, but he didn't put it on the form, right?
No.
Put the one and not the other?
No, just the one.
Hold on. Wait till you.
Go ahead.
Now talk.
Your Honor, I told her that she said, you have one sister. I said, I have my sister that's 29, and then I said, I have an 18-year-old
Why didn't you put it on the form?
When I was doing the form, Your Honor, I was just doing it fast. I wasn't thinking, Your Honor.
4 years ago you filled the form. You didn't put anything about there? You never said anything about it?
Because I feel ashamed, Your Honor. It's not a lie. My sister does have Down syndrome. I have an 18-year-old sister. Your Honor, I apologize that I didn't put it on there.
I'm not.
I apologize.
You were told when you went out here that you're going to meet with them. You need to be open and honest with them. They're going to check and verify everything you tell them. And you treated this. You put zero effort into this pre-sentence report.
Your Honor, I put as much effort as I could.
No, tells me something. That's the most effort you did. What you did, your effort you put forth in doing this questionnaire was the most effort you could put into that?
Yes, with everything. I just missed out my sister, my siblings. That's all, Your Honor.
You didn't put any employment. This shows you've never worked. It shows you have no assets, no obligations, no work.
I could recall that I did say I worked at PCC Airfoils in Popeyes.
Do you have the form? Well, you had a form to fill out. It's left blank. There's nothing on it. That's your best effort.
Yes, Your Honor.
Finish what you want to say.
Your Honor, I just want to apologize for everything, and I take full accountability for what I did. I know you're sick of seeing me. I know you probably think that I'm not going to do the right thing, but I actually do want to do the right thing. It's not about me. It's about my family and my kids. Thank you.
Thank you. Mr. DePiro for the state of Ohio.
Thank you, Your Honor. Mr. Nagorski, the owner of the vehicle that was stolen, paid $210.60 to Interstate Towing to get his car out after it was recovered, 2 days after it was recovered. So pursuant to law, the state would ask for an order the defendant pay that to Mr. Nagorski. Mr. Nagorski, I had several conversations with him during the pre-trial phases of this case. He was notified of today's hearing. He's not here. He trusts the court's discretion. As far as the state of Ohio's recommendation, I cannot say that the defendant is amenable to community control sanctions. So I'd recommend prison 12 months. The defendant has 106 days credit for time already served.
Thank you. This court has reviewed the pre-sentence report and investigation, the drug and alcohol. Well, that was, I'm getting confused with the other. Pre-sentence report and investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I considered everything that's been said here today by Mr. Nicholson, the defendant, his mother, the prosecutor, the recommendations from all the parties. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912. Notes the defendant's relationship with the victim facilitated the offense. Nothing makes it less serious. As for recidivism factors, all of these are here. Defendant has a lengthy history of criminal convictions as well as juvenile delinquency adjudications. He's been involved committing offenses, delinquent acts since he was 11 years old. And it's just been nonstop since. He's not responded favorably to previously imposed sanctions. He's been on probation before in juvenile court, and there was just multiple violation after violation. He's been on probation as an adult. He's been on probation to this court. He had a violation. I didn't send him to prison after his violation. I gave him another opportunity. We've given him NeoCap, jail treatment program, Lake House or Concord Pines, whichever one he went to. Pretty much all the resources we have here for treatment, and he immediately violated again. He got out and he's committed, this is not the first crime he committed after he got out. There's some misdemeanor charges there as well. I believe a TPO violation, a resisting arrest violation. No genuine remorse in regards to this offense. Doesn't believe he has any issues with drugs and doesn't need treatment. He smokes marijuana daily. No factors indicate recidivism is less likely. Under 29-2913B1, the defendant has previously served a prison term. Prison is certainly consistent with the purposes and principles of sentencing. And looking at the history, there's just no way this court could ever make a finding that this defendant is amenable to available community control sanctions. I can't make that finding. Excuse me. Therefore, it's a sentence to this court that on count 3, defendant served a term in prison of 12 months. He has credit for 106 days he's already served. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another, in this case, 6 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. I'm going to order restitution to the victim in the amount of $210.60, or that you pay off court costs, and disapprove any placement in any program of shock incarceration, intensive prison program, or transfer to transitional control. I will dismiss counts 1, 2, and 4 as agreed to between the parties as part of the plea negotiations in this matter. Mr. Giordano, if you're serious and sincere, you'll do your time, you'll get out, and you'll get the help you need, you'll get work, you'll do everything you say you're going to do. You don't need a court to order you to do that stuff. You could do that stuff on your own. And if that's what you're truly sincere about, then you'll do that. And we'll see. I hope I never see you again. But if you do something here, you're going to be back here, and we're going to have the same conversation again. And don't tell me how sincere you are then. But you can do that on your own. You don't need me to order you to do it. Is there anything else for the record at this time, Mr. DePiro?
No, Your Honor.
Mr. Nicholson?
No, Your Honor.
All right.